Welcome once again to Lehto's Law. Here's Steve Lehto.
I better do this story. I'm getting bombarded with emails from people saying, Steve, check this story out. It's one of the most requested stories I've had in a long time. I'm going to go with a version from the BBC. May as well just go out there for a distant source. Disney Plus terms prevent allergy death lawsuit, according to Disney. And widely reported, you can simply type in Disney and allergy, and you'll get this story from any one of a number of sources. Imran Rahman Jones wrote this. Disney World is arguing that a man cannot sue them over the death of his wife because of terms he signed up to in a free trial of Disney Plus a while back. Now, they're saying he can arbitrate the claim, but he cannot file a lawsuit. The man filed a wrongful death lawsuit against Disney after his wife died in 2023 from a severe allergic reaction after eating in a restaurant at the theme park. Now, Disney argues its terms of use, which were in his Disney account in 2019, means that they have to work this out without the court system. It's got to be arbitrated. So the trip to Disney World is one thing. The Disney Plus subscription you'd think is another thing, but Disney says, no, it's all Disney. Representatives for Disney and the man who has filed the lawsuit have been contacted for comment but have not commented yet. The man alleges that the restaurant at Disney World in Orlando, he and his wife dined at, did not take enough care over her severe allergies to dairy and nuts, despite being repeatedly told about them. She died in a hospital later that day, October 2023. According to the legal filing, her death was confirmed by a medical examiner as a result of anaphylaxis due to elevated levels of dairy and nut in her system. So they're saying it was actually two things. So the man filed a lawsuit, and every story I've said he's suing for $50,000 or in excess of. And you have to understand that that's simply a threshold that you plead. You're saying, I'm looking for damages in excess of $50,000 plus legal costs, and you're asking for that just to make sure that you're in the correct court that can give you what you're entitled to. Below that, you go to a different court. Now, Disney wants the case thrown out of the court and sent to arbitration because they say they're entitled to that. The entertainment company argues it cannot be taken to court because in its terms of use in its Disney Plus subscription, it says users agree to settle any disputes with the company via arbitration. So presumably, if you went to visit wherever Disney's headquarters are and you're walking down the hall when you slipped and fell due to their negligence and broke your leg, you couldn't sue them. You'd have to arbitrate if you've got a Disney Plus subscription or ever had one. It says here that they're arguing that the man agreed to those terms when he signed up for a 1-month free trial of its streaming service Disney Plus in 2019. So apparently he signed up for a 1-month free trial, and in exchange for that, he also waived any rights to sue Disney going forward. Disney adds that the man accepted these terms again when using his Disney account to buy tickets for the theme park in 2023. Now, that's a stronger argument because the Disney Plus subscription is a streaming service. You'd assume that you're agreeing to arbitrate any disputes you have about that service you're signing up for. You wouldn't think, I'm also going to be waiving any rights I've got if I ever go visit Disney World or Disneyland. I'm going to Disneyland. The man's lawyers called Disney's arguments preposterous and inane. I like that. They say Disney's case is based on the incredible argument that any person who signs up for a Disney Plus account, even free trials that are not extended beyond the trial period, will have forever waived their right to a jury trial. The argument that this can be extended to wrongful death or personal injury claims borders on the surreal, according to the attorney's filing. They also argue that the man agreed to the Disney terms of use for himself, whereas he is now acting on behalf of his deceased wife, and she never agreed to the terms. And keep in mind that when someone passes away, you can file a lawsuit for your damages, but you can also file a lawsuit on behalf of their damages if, in fact, you are legally entitled to do that. It's complicated, but we don't need to go there right now. So Disney is pushing the envelope of contract law, says a partner at a law firm who was asked about this, but was not involved in the proceedings. The courts will have to consider, on balance, if the arbitration clause in the contract for a streaming service can really be applied to as serious an allegation as wrongful death through negligence at a theme park. He also added Disney's argument that accepting the terms and conditions for one product covers all interactions with the company is novel and potentially far-reaching. So what I would tell you is this. I have a Ford Explorer that's got an infotainment center on it. And when I was being shown how it worked by the salesman, he pulled it up and there was terms and conditions. He goes, yeah, you got to click this to make that work. And he clicked it. But let's assume for a moment that he did that as my agent, okay? I didn't read it. I don't think he did either. So what if buried in there somewhere was a statement that said, by accepting these terms and conditions, you agree to arbitrate any claims you have with Ford Motor Company arising out of, warranty on this vehicle, or any negligence or product liability claims on this vehicle, and you cannot sue us. You gotta arbitrate those claims. Would that be fair? So another person that asked about this said that the argument regarding the terms in the Disney Plus trial are a weak argument for Disney to rely on. However, the clause in the ticket purchase may be stronger as there is a similar arbitration clause. And again, the arbitration on the streaming service, you'd think common sense would dictate that it addresses the streaming service. But the ticket that you're buying to go to the theme park, you agree with these tickets, I'm agreeing to arbitrate claims that arise. You'd presume that would arise from your visit to the theme park. But then, of course, the question is, if you buy 2 or more tickets and one person clicks that box, can they speak for the other person? That's a question. That may permit Disney to stay the case for arbitration, he says, although there are many other threads that may prevent them going to arbitration given the delicate circumstances in this case. That's another legal expert they talked to. So the man wants the case to go in front of a jury in a court of law. Disney's motion to take the case out of court and decided arbitration will be heard in front of a judge in Florida in October. Arbitration means a dispute is overseen by a neutral third party who is not a judge. Keep in mind that I'm not familiar with who Disney uses, but quite often, and I've joked about this before, if I can pick where we play the game and the rules of the game, I can win the game. And arbitration is often like that. So if a big corporation signs a contract that says we're going to use this entity to arbitrate our cases, and this entity is arbitrating cases, are they inclined to rule in favor of the one-off people who come in and file claims, or in favor of the big company that keeps paying their bills? I'm just asking the question now, okay? It says here that arbitration is quicker and cheaper than a court case, usually. That might be true, but it's not worth the trade-off. We'll get there in a second. Meanwhile, another law expert says Disney understandably may want to benefit from the privacy and confidentiality that arbitration brings rather than having a wrongful death suit heard in public with the associated publicity. And now the question is whether or not it will actually be private and confidential, because it's true that it wouldn't be public in the sense that people could go watch the arbitration. But quite often, you can talk about an arbitration after the fact. It's just that it won't be as flashy and probably not over the front page of the news. But I can tell you, and right now, there's somebody in the comments going, Steve, what have you got against arbitration? It's faster. It's cheaper. And what's the difference? Well, besides the fact I've already pointed out the obvious bias of an arbitrator who's hired by a big corporation to handle a lot of cases for them, I've seen cases where arbitrators got fired. I've actually dealt with a case before where I know for a fact that the arbitrator got fired because of the result they gave somebody. And the company actually said, you know something, we won't use you anymore, we'll use somebody else. And I can't get into the facts of that case on camera, but I assure you it's true. I can also tell you that in my career, I've probably arbitrated maybe as many as 50 cases, maybe not quite that many, 30s, 40s, right around there maybe. But I can tell you that in all those arbitrations, I've gotten some where my client got exactly what they're entitled to. I've had some where my client got nothing. I've had some where the arbitrator cut the baby in half and, settled the case that way or resolved the case that way. I've also had an arbitrator give my client more money than they were entitled to. Absolute fact. Went into the arbitration. I said my client is entitled to this much money. My opponent said his client's entitled to zero. Zero versus this much money. The arbitrator got upset at the position of the defendant and awarded my client this much money. They're entitled to this. They're not entitled to this. And my opponent called me up and said, Steve, you seen the arbitration award? And I said, yes, I have. And he said, are you willing to stipulate to drop it down to the amount your client's entitled to? And I said, I was thinking about that. Because as a matter of principle, and I am a man of principle, I can see why you think my client's not entitled to that. I said, but if the arbitrator gave my client zero, and somehow I could convince you that they were entitled to more, would you agree to move it up? And he goes, well, I said, let me ask you this. Have you ever called up the other side and agreed to a middle number after you got an award you didn't like? He goes, no, I haven't. And I go, so no, my client's not going to allow me to do that, so no. And he said, well, I'm going to file a motion and have this set aside. I said, based on what? He goes, your client's not entitled to that money. I said, oh, no. They are. An arbitrator said so. See, arbitrations generally aren't appealable. And that's the problem. Another problem is that arbitration quite often will say that the arbitrator can do what they think is fair. Now, sometimes it'll say that they must follow the law of a particular jurisdiction. They must follow certain procedures. But I've also seen it where they say, oh, but many of these rules are relaxed and are up to the arbitrator to decide what is fair. So, again, the arbitrator who gave my client more than they're entitled to, that's an anomaly. I've told that story to other attorneys, and they're like, whoa! But it wasn't like they were given $1 billion and they're entitled to 5, okay? It was the thousands. It was in the thousands of dollars. And I actually know what the arbitrator is doing besides the fact that he was annoyed at the defense attorney, okay? But that's not the point. I've also had a case where we got stuck on something in court. We got stuck on something where I was convinced my client should get this, and the other side said my client should get this. And let's assume both of those are things, okay? So in other words, we both agree my client should get this or this. We just can't agree on which it is. Assume it's a binary proposition. My client gets one but not the other, or this one but not the other, okay? And the judge said, something, short of flipping a coin, I don't know what to do here. And I said, well, I'm kind of stuck too. And the judge goes, why don't you arbitrate just this question? And it'll cost you a couple bucks to hire an arbitrator for the afternoon, but an arbitrator can hear these facts, pick a winner, and that way you're done with it. I said, oh, okay, I'll do that. Other side says, I'll do that. So we went and met with the arbitrator and said, this or this, pick a winner. Arbitrator rendered an award where he picked the third option. I don't know if you know how radio buttons on cars work or binary propositions. Okay? When they flip the coin at the Super Bowl, they don't go call it heads, tails, or lands on edge. It's either heads or tails. And I got the award, and I'm looking at it going, huh? Like I thought the guy had... And I actually called his office and said, is this... I didn't speak to him. I spoke to his secretary. I said, can you double check to make sure this is correct? Because he sent over an award that makes no sense. And she said, yeah, he said that's for you. So I call my opponent and go, hey, did you get this award? And he goes, yeah. I go, that's not one of the choices. And he goes, yeah, you're right. And the problem, of course, is you can only appeal arbitrations on extremely narrow grounds, and it's usually things like the arbitrator was committing some kind of fraud or took a bribe or something. And I actually filed a motion on that one. I actually asked the judge to review it. And I said, Your Honor, you recall we were in front of you. It's either going to be this or this. We decided to arbitrate the issue, and the arbitrator picked this. And the judge goes, I wouldn't have expected that either. But there's no evidence of fraud or anything, is there? And I said, no. And he goes, well, I'm going to let it stand. And you can get these really bizarre results from arbitration, and they're not reviewable. Or if they are reviewable, a judge is likely going to go, I'm going to let it stand. Because, it's not my mistake. It's someone else's mistake. And so the idea that the Disney Plus terms, when he signed up for the free account for 1 month, that would block the wrongful death case and make it go to arbitration, to me is so absurd. I'm surprised they raised the argument. The better argument was that when he bought the tickets, he agreed to arbitration. But the question is, when he buys the tickets and agrees to arbitration, is he doing it on behalf of both people using those tickets? Is that enforceable as a matter of law? But I hope it's not. But again, I know that people say arbitration is cheaper, it's faster. Again, if you want to play a game with me and you let me pick the playing field and let me pick the rules and let me pick the referee, I'll win every single time, or close enough to make it look real. So again, thank you to everybody who sent it to me. This version from the BBC, and Imran Rahman Jones wrote that. Disney Plus terms prevent allergy death lawsuit, according to Disney, or the terms that came with purchasing the tickets online. Questions or comments? Put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Now, let's proceed in an orderly fashion.